Hi everyone, you're very welcome once again to Trinity's Masterclass on Exploring Consent in Health Research. My name is Evelyn Fox and I'm the Deputy DPO with responsibility for research in Trinity College Dublin. So I'll be chairing today's Masterclass, and as many of you will be aware, several amendments to the health research regulations published in January of this year focus on consent. And in today's Masterclass, we wish to explore these particular amendments in more detail. So we're very fortunate today to be joined by three keynote speakers who will each give their perspective on consent. Peter Lennon works in the R&D and Health Analytics Division of the Department of Health, where he has responsibility for the health research regulations. Peter has written 2 books on data protection and numerous articles. He has also lectured on health service management. Thanks for joining us today, Peter, at least in audio. Emily Verica is the Programme Manager of the Secretariat to the Health Research Consent Declaration Committee. Emily has overseen operations in the Secretariat since it was established in early 2019. This includes advising on the consent declaration process and supporting the HRCDC to deliver its mandate. So welcome back to Trinity today, Emily, albeit remotely. And our final speaker today is Professor Mary McCarran, who is the Chair in Ageing and Intellectual Disability in the School of Nursing and Midwifery in Trinity College Dublin. She's also the Director of the Trinity Centre for Ageing and Intellectual Disability and the Principal Investigator on the Intellectual Disability Supplement to the Irish Longitudinal Study on Ageing, or IDS-TILDA. Finally, Mary is the Executive Director of the National Intellectual Disability Memory Service in Tallaght University Hospital. Consent is fundamental to Professor McCarran's research work with the intellectual disability community, and she's taken a keen interest in the health research regulations since her time as Dean of the Faculty of Health Sciences. So thank you, Mary, for joining us today to give us your unique insight. And last, by no means least, joining us on our panel today, we are delighted to welcome David Murphy, Assistant Commissioner in the Data Protection Commission, with responsibility for supervision and freedom of information. Having joined the Commission in 2016, David has been providing best practice guidance and advice to organisations across the public and private sectors on data protection compliance. David is also a member of the European Data Protection Board. So we thank you, David, for taking the time to join our panel today. And I would now like to invite Peter Lennon from the Department of Health to present to us on the concept of consent in health research. Thank you, Peter.
Firstly, thanks to Evelyn and our colleagues for organising this masterclass. We had an event last week, which I think was very positive, and today I'm going to go on from that to look at consent from a legal perspective in health research. I'm going to stick to the 20 minutes, but I'm going to have to say something. Sticking to 20 minutes does not do justice to this complex subject. So like my colleague Emily, what we're going to do is use this presentation for 20 minutes, but then send in a more extensive presentation that can be readily available. Okay, so why consent and why explicit consent? When the health research regulations were made in 2018, much was made of the inclusion of a requirement for explicit consent as a safeguard. Was the reaction to that requirement justified? Well, to be honest, I don't think it was, particularly given that informed consent was a requirement prior to the introduction of GDPR and health research regulations, and that really all that the explicit consent requirement did was make it more readily recorded and documented. This presentation explores why explicit consent was included and the changes made to the amendments on consent in the health research regulations in January of this year. So, a lot of discussion on what is valid consent, but it boils down essentially to a few basic points. It's freely given or voluntary, without any element of inappropriate pressure or undue influence on the data subject. Can I just make a point? Because some people tried to say there was a difference between freely given and voluntary. There is no difference between freely given and voluntary. Without any element of inappropriate pressure or undue influence, well, we can see why that would be important. And in that regard, I would say, obviously, if you're a healthcare professional who is treating a patient or a client, when you are seeking consent from that patient or client, you have to be extra careful that you do it in a way that ensures that the consent is freely given or voluntary. And in researching this paper today, I found evidence that this was being discussed as far back as 2003. So it's not a new issue, it's an old issue. Informed. Consent should always be informed. In other words, you should have as much information as you need to be able to make the decision. And a corollary of consent being informed is that it should be timely. In other words, you should be given time to consider what you've been told in order to reach an informed decision. It should be as specific as possible. It can be broad, but not blanket. So as specific as possible, but it is possible for it to be broad, but not possible for it to be blanket. Consent must always be capable of being withdrawn, although in some studies, withdrawn consent may raise difficulties for the study, and that's addressed in the General Data Protection Regulation. Capacity to consent is present. We are going to discuss capacity to consent. After all, you can't make an informed decision and act in a freely given or voluntary way unless you have capacity to consent. And capacity to consent is an old issue, but it certainly has been much in the news in recent years. I think the most important thing I'd say is that consent must always be based on a good faith principle. If somebody was seeking your consent for something, would you be surprised by what you later discovered had been done to your information or who had access to it? So basic guidance for all healthcare researchers: act on a good faith principle. And to make the consent explicit, informed consent and explicit consent. Well, I can sum it up like this. Explicit consent is simply informed consent that has been documented and recorded. Why is consent important in health research? Patient empowerment. People should know what's happening to their information and have control on it. Patient trust is at the heart of the relationship between an individual patient and his or her healthcare professional. If you tell your doctor something, you don't expect it to be repeated. The best way to support health research is to enhance public confidence in health research, and transparency and consent are the keys to making that happen. I will acknowledge this, that in this country, we do need a big debate to take place about making more health information more readily available for research. But that needs to be an open and honest debate. We need to have it soon, because I think, particularly with genomics, it's an issue that needs to be resolved. Informed consent in health research. This is a statement by the EU Commission. I won't read it all because you can look at the slide later. The EU Commission has unequivocally stated the importance of consent in research. Informed consent is the cornerstone of research ethics. And the Commission document goes on to say that you must keep records documenting the informed consent procedure. In other words, they're saying that the informed consent procedure must be documented, which in a sense means they're saying that it must be explicit. Right, next slide if I can find it. The legal framework for processing personal data in health research. This was a slide that I had last week. So in terms of the law in this area, at an international level, you have the European Convention on Human Rights and decisions of the European Court on Human Rights. Ireland has ratified that convention. You have the EU Charter of Fundamental Rights, and then you have the EU Data Protection, General Data Protection Regulation. At a national level, you have the Constitution, and the Constitution has a right to privacy. The common law governs the duty of confidentiality, and the Data Protection Act is about the processing of your information generally. And the health research regulations flow from the GDPR, the Data Protection Act, and the health research regulations. So confidentiality and consent, ethical and common law. The common law duty of confidence, which derives from ethical principles going back to the Hippocratic Oath, survives death, unlike data protection law, which applies only to living individuals. In other words, your doctor is under a duty of confidence not to disclose your personal information, even after you die. Now, recently there's been some prime time coverage of the issue of confidentiality and consent. Dr. Rita Doyle, president of the Medical Council in March 2021 said, patients and their families should not have to worry about their private and personal information being disclosed without their consent. There are very few limited circumstances when a doctor can disclose information without consent. And the Supreme Court in the National Irish Bank versus RTE affirmed the view that there is a confidential and privileged relationship between a doctor and patient. So confidentiality, very important. It goes back hundreds of years and is not to do with data protection, but with the ethical concept that what passes between a healthcare professional and his or her patient should be confidential. Now, what about the health research regulations? They don't make consent the legal basis for processing personal data for health research. The legal grounds are set out in Article 6 and Article 9. But Article 9.2j, which deals with the processing of personal data for scientific purposes, does state that where that is done, there must be suitable and specific measures in place to protect the fundamental rights and interests of the data subject. So it's saying that there must be safeguards. Go back to the EU Commission document. It says that informed consent is a cornerstone of good research ethics and necessary for health research and the processing of personal data. It's interesting too that Article 9.4 of the GDPR states, member states may maintain or introduce further conditions, including limitations with regard to the processing of genetic data, biometric data, or data concerning health. So the GDPR always recognized that when it comes to personal health data, particularly genetic data, it's important that there should be additional safeguards over and beyond what is in the GDPR. Now, the next slide is going to deal with those suitable and specific measures, which are set out in Section 36 of the Data Protection Act 2018. In other words, remember what I've said, Article 9.2J deals with processing of personal health data for research purposes. There must be suitable and specific measures. They are set out in Section 36 of the Data Protection Act 2018, and the very first one that you will see is explicit consent of the data subject for the processing of his or her personal data for one or more specified purposes. So it wasn't that the health research regulations introduced the concept of explicit consent. They were already set out in the Data Protection Act. And because it's a safeguard, rather than an Article 6 ground or Article 9 condition, the January Amendment is able to frame the requirement for explicit consent in terms of international best practice on the ethical conduct of health research. And that includes informed consent, which has always been there, transparency, which is the core data protection principle, and independent ethical oversight, which has been there for several decades now. The explicit consent safeguard can cover specified health research, either in relation to a particular area or more generally in that area or a related area of health research. In other words, it allows for broad consent. Broad consent, but again, I repeat, not blanket consent. So there are three coexisting consents that you have to be aware of: the constitutional right to privacy, the common law duty of confidentiality, and the GDPR consent provisions. They sit alongside each other. And to process personal data lawfully for health research, they must all be met. And that's why the consent declaration process in the health research regulations is set at substantial public interest. That's to make sure that it meets the common law and constitutional thresholds. It's also why, as a practical measure, consent should be documented and recorded as per the amendment to explicit consent. In other words, what we're saying the whole time is this: explicit consent, which is the recording of informed consent, serves several purposes. It avoids confusion between the health researcher and the participant as to what exactly they agreed to. Capacity to consent. Okay, I'm going to kick off by saying that something that you probably already know, which is that in terms of the health research regulations, they can only cover the processing of personal data for health research. It can't cover, for example, somebody's participation per se in a clinical trial. They don't cover taking extra blood in order over and above the clinical need in order to have it for research purposes. So what I'm talking about in this area of capacity to consent is the issue of consent to process personal data. Now, some people here will be aware of the fact that under the Data Protection Acts 1988 and 2003, there actually was a provision that provided that if the data subject, by reason of his or her physical or mental health or incapacity or age, is or is likely to be unable to appreciate the nature and effect of consent, it may be given by a parent or guardian or a grandparent, uncle, aunt, brother or sister of the data subject. Now, that's quite a wide range of people who could give consent in a situation where the individual couldn't give consent. However, the General Data Protection Regulation does not allow anyone to give consent on behalf of another adult. Is that problematic? It may well be. Remember that GDPR does not allow anyone to give consent to another adult. Therefore, you would have to say that if that's what GDPR says, then Ireland could not introduce a law that would allow another person to give consent on somebody else's behalf. And that's why in the health research regulations, we don't allow the Health Research Consent Declaration Committee to give consent on somebody's behalf. We allow them to disapply the requirement for consent. So Article 9.2c of the GDPR allows processing of personal data where it is necessary to protect the vital interests of the data subject or of another natural person where the data subject is physically or legally incapable of giving consent. So in other words, Article 9.2c says you can't get somebody else to give consent on your behalf, but your personal data can be processed in those exceptional circumstances. So what about the Assisted Decision-Making Capacity Act 2015? Many of you will be familiar with it. The legal concept of capacity to consent is developed over the centuries. The Assisted Decision-Making Capacity Act is the principal legislation dealing with this area. Not all provisions of the Act are commenced, and even now the government is intending to revise and review that Act. Responsibility is moved from the Department of Justice to the Department of Children, etc. So health research and the 2015 Act. Under the 2015 Act, health care is referenced, but not health research. If you want to include health research in the 2015 Act, the only way that it can be done is this. You would need to have a specific amendment to the 2015 Act, specifically including health research and what health research meant. So the Deferred Consent Amendment, to the extent that we could do something in this area, we did it and pushed it as far as we could. So we allow for deferred consent in a situation where the giving of consent to a particular treatment and the accompanying inclusion in the research study is not possible because of the type of medical situation emergency involved. The vital interests of the individual concerned are engaged, and decisions made by clinicians are made in the best interest of patient care. So what type of situations are we talking about with that amendment? Well, the type of situations that we're talking about are set out in this slide. The deferred consent provision would be applicable where there is urgency caused by a life-threatening or other serious medical condition. There are reasonable scientific grounds to expect that participation will have the potential to benefit the patient. The study relates directly to the subject's medical condition, and the study poses no or a minimal risk to the individual concerned compared with the standard treatment. What we would say, strongly advise, is that in order to take advantage and use this amendment properly, hospitals should develop a protocol for deferred consent scenarios that will guide clinicians and researchers in making decisions. So what happens about obtaining consent? Well, if you use deferred consent, what you have to be prepared to do is when the individual regains consciousness or regains capacity to consent, you have to obtain the informed consent as quickly as possible. That's basically what it means. And you also have to inform the individual whether during the time that he or she lacked capacity and the data was being processed, whether it was being shared with another party at that time. So if the deferred consent is not given, well, it basically means that the processing has to stop. And any personal data already processed for the health research purpose shall be erased, except where to do so would be likely to render impossible or seriously impair the achievement of the objectives of that processing. That term is in the health research regulations, but we had to take it directly from the General Data Protection Regulation. So it's the General Data Protection Regulation rather than health research regulations that provides for that caveat. Any personal data that was processed that is necessary for the care and treatment of the patient is not affected by a decision not to give deferred consent to the research study. In other words, we're saying that even if an individual pulls out of the study, his or her medical records that have been compiled for his or her medical treatment, they have to be maintained, which seems reasonable. Applying to the HRCDC, Emily may well pick up this point, but the whole purpose of this amendment in engagement with the health research community was to ensure that you didn't have to go to the Health Research Consent Declaration Committee. The last subject I'm going to touch on within the time concerned is genomic research. There are significant, even life-saving benefits to sharing genomic data for healthcare and medical research. Let's face it, it's a real game changer in terms of medical care, and its potential is basically unlimited. Large-scale genomic databases are likely to become increasingly common. We already see the development. Those databases and the underlying biobanks give rise to substantial legal and ethical challenges, particularly given the potential to facilitate criminalization and discrimination. They also raise a big issue that has to be faced. When it comes to consent, how broad can consent be in the genomics era? And who does it have to be obtained from? In other words, just the individual concerned or his or her family as well. Big issues. I've set out a few more challenges. The area even raises basic questions about the definition of personal data associated with the data protection model, because the definition of personal data in the data protection model is not about personal data about you or me. It's about personal data relating to an individual, which is much broader than about. It also raises challenges for the potential to actually anonymize personal data. Is that possible? There's also issues about fulfilling data subjects' rights under the GDPR. For example, providing information to satisfy the requirement of informed consent and ensuring complete withdrawal from research when requested. One of the issues that frequently arises in terms of genomic research is that the people carrying out the research say it's not possible to withdraw your information in any real way after a particular point has been reached in the research project. It's unclear who will enjoy subject access rights to the data held, that is just related to the individual in the study or his or her families. Is the traditional distinction between research and clinical care really viable any longer? And in terms of genetic inheritance right of bidder, if I participated in a study and people carrying out the study found out that I had a condition which related to more than me in terms of my family, do I have a right to veto them telling the members of my family about something that might be particularly relevant to them in terms of their medical care and treatment? So all in all, big issues. What is required? I think everybody in this area would say clarity, consistency, and certainty at national and international level in terms of data protection, ethical considerations, and other regulatory matters. The European Data Protection Board is considering genomics research in the context of its guidance on health research generally. It probably needs much more comprehensive guidance. Viewing consent is an ongoing process that involves discussion and dialogue rather than a one-off exercise. That is undoubtedly going to be the case when it comes to genomic research. It won't be a case of getting consent once. Those that engage in genomic research will have to engage in a process that's ongoing as a dialogue in terms of going back to the individuals concerned. In terms of legislation, it's undoubtedly the case again that primary legislation supplemented by codes is needed to comprehensively regulate biobanks, genomic samples, and genomic research. I think anybody carrying out research in this area knows that the absence of such legislation is very problematic. A step in the right direction. The National Research Ethics Committee bill provides for national research ethics committees. Undoubtedly, one of those ethics committees will be in the area of genomics. And finally, most important requirement for everybody involved in this area is an open mind when debating the issues.
I'd now like to invite Emily Verica, Programme Manager of the Secretariat to the HRCDC, to present to us on the role of the HRCDC. So thank you, Emily.
That was a great introduction from Peter around consent in general, and I think set the scene up very nicely for me. It's a hard act to follow. So I'm just going to jump straight in and give an overview of the concept of a consent declaration. So this is a statutory mechanism that enables researchers to process or further process personal data for health research, where explicit consent cannot feasibly be obtained and where it is in the substantial public interest, and where suitable and specific measures are taken to safeguard the rights and fundamental rights and freedoms of research participants, and where all requirements of the health research regulations are met. So the HRCDC, just to give a quick overview, it's a ministerial appointed committee which comprises 17 members, 3 of which are patient and public care representatives. And they bring to bear a wide variety of expertise within the committee, such as general practice medicine, genomics, sociology, epidemiology, etc. And they have the power to consider research applications seeking a consent declaration and effectively make 3 decisions when they're convening. One is to make a consent declaration. They can also formally request further information from after applications have been received, if there's particular gaps in information, or they may not make a consent declaration. They also have the powers to revoke a consent declaration if it's deemed that it has not been implemented or complied with sufficiently. They also can consider amendments to an existing consent declaration, and it's a consensus-based decision-making process that the committee would operate under. The Secretariat supports the HRCDC in all aspects of its work, and with me are two excellent colleagues, Johnny Barrett and Caroline Burns. So we collectively support the HRCDC. We're responsible for the application process, and we act as a point of contact for the research community. We manage all all the applications, and we have a database of applications which is actually viewable on our website. So you can see the log of applications on their status and the decisions made about them on our website. We draft and publish the minutes. We finalize the decision letters which are sent out to applicants. We also monitor the declarations on behalf of the HRCDC, and this is primarily carried out through the annual review, which an applicant must submit to the committee on a yearly basis. And we also facilitate training and professional development for the committee in areas which they may, if they wanted more information about technical areas such as genomics or biobanking, etc. The last meeting, for instance, we had this Central Statistics Office in providing an information session on the COVID-19 Data Research Hub. And a lot of the work would be carried out in consultation with the chairperson, Bridget McManus, and other members of the committee. So the application process is relatively streamlined, and it's set out as follows. So once an applicant submits an application to us, the Secretariat will triage it and run through it to make sure that it has all the sufficient information to enable the committee to make its decision. If there are additional queries we will revert back to the applicant, and those responses then will be submitted to the committee about 10 working days in advance of the meeting. And then at the meeting itself, there will be deliberations, and then a decision will be made by the committee. And the applicant can then accept the decision, or if they do not accept the decision, they have the right, as set down under the regulations, to formally write to the Minister and request an appeal panel to be convened and to appeal the decision of the HRCDC. And so we do prioritise new research studies and COVID-19 research studies, in addition to progressing older applications that would have come to us back in 2019, etc. And so from submission to the decision, you're looking at approximately five weeks or so a turnaround time. So this is just a snapshot of the activity in 2020 with a very busy year. So at the start of the year, we had 86 applications, 39 new applications were submitted to us, and 49 decisions were made. 34 consent declarations were made, and 6 applications did not receive a consent declaration. What I would also highlight is that we convened 17 times last year, which is quite unprecedented. An extra 6 meetings were put on specifically to deal with COVID-19 research applications. And we did this in collaboration with our colleagues in the National Research Ethics Committee, where we collaboratively pulled together a one-stop application form for ethics and the consent declaration process. And led by the COVID-19 National NREC, we received applications from them. So there's a rapid response to both an ethics approval and a consent declaration carried out for those COVID-19 research studies at that time. So the scope of the research that we would typically see is very wide and varied. We see a lot of retrospective chart reviews, for instance, the National Adverse Events Study, retrospective observational studies. So GSK would have sponsored a study and working with Irish clinical sites to evaluate the effectiveness of treatment for influenza. So it's a post-authorization study. We've seen a lot of clinical trials, and to notably there, the World Health Organization-led Solidarity trial would have sought a consent declaration, and this was led by the joint data controllers, the Dept of Health and UCC. We've also seen a lot of studies in other areas such as genomics and genetics. For instance, the Irish Coronavirus Sequencing Consortium led by Paul Cotter in Teagasc, and longitudinal studies, which we've worked closely with Mary on the IDS tilde longitudinal study. We've also seen biobank studies come to us as well, seeking a consent declaration for the data processing that would be associated with tissues being held in those biobanks. And I've also seen some registries come to us as well for data processing, such as the National Self-Harm Registry and the registry held by the Alpha One Foundation. Data controllers, we have seen, there's many data controllers that come to us, data controller organizations that are leading these studies, and unsurprisingly, within Ireland, they are very much concentrated around Dublin, Galway, Cork, etc. And these would be linked to the clinical research facilities and affiliated universities and hospitals. We've also seen some more international data controllers seeking consent declarations for studies. They may be led by data controllers coming from New Zealand or Europe and the US. Some may be joint controllers with Irish sites. And the important thing for the committee is to have assurances that where there is an international data controller, then the consent declaration, if made, is enforceable in Ireland. So therefore, the Irish sites must be able to support that declaration to ensure that the Irish research participants are able to exercise their data protection rights effectively. So some considerations around consent declarations. So when to apply for a consent declaration? So an applicant or a data controller organization must have a strong evidence-based, substantiated reasons for seeking a consent declaration. So a consent declaration is not a substitute for seeking consent. And there may be a number of factors as to why a consent declaration is required and necessary to get. It may be in relation to the number of participants. It may be to do with the size of the study, if it's a multi-site international study, or to do with the vulnerability of participant groups, such as those with intellectual disabilities. The sheer volume of data can also influence whether or not a consent declaration is required, such that consent is not possible to achieve. So there could be a data collection over a decade, which is required for a particular research study. Sometimes seeking consent may create a biasness in the study or decrease the quality of the data that might be required, so compromising the integrity of the study. And I suppose last year we would have seen a significant amount of research studies in the area of COVID-19, and in those scenarios, the participants either it would have been difficult to get consent because of infection control measures, or because of their decision-making capacity may have been compromised at that time, either in the short term or long term. So the considerations that the HRCDC would take on board, there's a series of questions that they would ask. And most of these questions are set out in the application form to ensure that the committee fully understand what has been done with the data for the study. So why consent cannot be obtained? Has this been discussed with the research ethics committees? And are there opportunities to seek consent at any point in time during the study? Examples, so if there's follow-up care and treatment, can those participants be consented later on? And is there patient and public involvement? And I'll talk a little bit about that later on as well. So the other important, obviously, the key factors around the public interest, and will the study be sufficiently impactful to justify not obtaining consent, on balance with the safeguards in place to ensure the rights and freedoms of participants are upheld. So all of these are factors, and these are just a snapshot of some of them. So ultimately, as set out in the regulations, in order for the committee to make a decision, there must be substantial public interest in the study, and it must significantly outweigh the public interest in requiring consent from the individuals who are participating in the research. So a consent declaration is made solely to a data controller or to joint data controllers, and it covers the processing of data. And this is, as you will know, can be a series of activities such as collecting, using, storing, sharing, pseudonymizing data, retaining data, etc. It's not transferable to any other third party. It is specifically for the data controller carrying out the study and the processing they are doing. It's generally time limited. In some scenarios, such as long-term studies, longitudinal studies, or long-term data processing associated with biobanks, there may be a significant duration to the consent declaration, which will be under review, through the annual review process. And more often than not, conditions are attached to the consent declaration. Each declaration will have a defined scope as to what it covers, what processing it will cover. And this is just an example, apologies for the lengthy text, that processing of the data for this particular study was limited to retrospective collected data, so data that was already in existence. And interestingly, the committee did not make the declaration to cover prospective participants who will be tested for COVID-19 in the community setting. And this is based on the study that was the Irish Coronavirus Sequencing Consortium. So I'm just going to run through some conditions that would typically be attached to a consent declaration. And these are effectively safeguards that would mirror the safeguards as required under the health research regulations and indeed GDPR. So patient and public involvement is it's a very important safeguard that the committee would focus on, as patient and public involvement would help create a more patient and public approach, and it ensures that the perspective of patients and their families and the public are taken into account, not only when designing and conducting a study, but also ensuring that the consent protocol would be appropriate. And it also is a way of enhancing the level of transparency around a study. Transparency, as I said, is a key data protection principle, and often the committee may request that these transparency measures are enhanced to ensure that people are aware that their data is being used for particular studies. And this could be by way of posters or notices in a hospital setting or a clinical setting. Study information leaflets and consent forms, these also are crucial documents which effectively empower the participant to make a decision about what their data is going to be used for, and allows them to have control over their own data. So observations from the committee would be that some of the information leaflets would be quite technical and maybe overly lengthy in some cases. And I know this is a difficult balance to meet when you're trying to impart all the relevant information, which can be quite significant when you're bringing data protection rights into the mix as well. And it must be readable from the perspective of the participant. And sometimes there may be technical errors or things not quite clear in consent forms, such as the mistaken interchangeable use of assent versus consent across information leaflets. So consent should only be used when engaging with the research participant, but proxy assent is an important data protection safeguard, but doesn't have any lawful basis for data processing. Full research ethics approval, often if you're looking at a multi-site study, you may have REC approval in one particular site, it may be pending in another, and it may not have commenced in another site. So the committee would also always ensure that there's a condition that that data processing can only commence at the research site where full ethics approval has come in. And data minimization, again, this is an important principle of data protection, whereas only the required minimal amount of data should be used for any one study. So for example, using the age versus the date of birth. Contractual arrangements, again, this is drawing down from the requirements under GDPR when transferring personal data to other third parties. And again, the committee would need assurances that all the appropriate arrangements and agreements are in place between the different parties who are processing data, whether they're processors or joint controllers, etc. All those arrangements are in place. And so in the case where there's a no declaration is made by the committee, there can be a variety of influencing factors that might contribute to a decision. And again, these are just a snapshot of things that might come into play. So poor rationale for no consent, so citing lack of resources or distress or biasing results. Those reasons in isolation would not be sufficient and would be considered by the committee. If there's opportunities to seek consent that are evident, then the committee may deem that actually consent can be achieved. If there's inadequate transparency measures or the data flow and transfer is not clear, if it's considered that the data protection risks are quite high, coupled with the volume of data being used or the sensitivity of data such as genetic data or sexual health data. And then we would communicate these decisions to the applicant and explain the rationale as to why the committee has come up with that decision. So in the case of where a no declaration has been made, then we would set out the reasons why, and on balance, all the aforementioned points of discussion would be considered, and it would be the opinion that the public benefit and interest in the study did not significantly outweigh the public interest in the requirement to seek consent. And so we like to operate a kind of an open door policy and have open engagement with our applicants. And in certain cases, the committee may like to kind of communicate back to the applicant that even though a consent declaration was not made for a particular study, it may be the case that they could resubmit a more substantially different application if there were material changes. And if that was the case, then any issues raised would be expected to be addressed by the committee. So I think that's important, important thing to highlight. So some of the questions that we've received recently, following on from the previous webinar, was what is the role of the HRCDC post-amendments? And the HRCDC still continues to consider applications in areas where effectively the amendments don't apply. So for instance, any researcher accessing the COVID-19 Data Research Hub, they would be required to seek a consent declaration. If there are participants that lack decision-making capacity, if retrospective chart reviews, for instance, are deemed high risk or medium risk, effectively they don't meet the threshold under the amendment, which is you have to be a low risk retrospective chart review. And yeah, so that's generally it. So the role of the committee is still quite valid, and effectively they will make decisions on applications where consent cannot be obtained. So that's a wrap from me. And the last thing I would say is that I will, as Peter point out, follow up with a more detailed slide set to give more context. And if any organisation wishes to get a more detailed presentation from the Secretariat with more specific context, we're more than happy to do that. So feel free to get in touch.
Thanks very much, Emily, for that presentation. And I think in particular, it would be really helpful to researchers to see maybe some of the pitfalls that they can try to avoid when putting in applications to you. And just to let you know that there's been a very positive comment from a participant about the transparency of the HRCDC, the fact that you publish your minutes and the application database. I think people really find that helpful. So nice to get some positive feedback now and then, isn't it?
Yeah, that's great. Thanks, Evelyn.
Great. Okay, so next up we have Professor Mary McCarran is going to present to us on her invaluable experience of gaining consent when conducting research with the intellectual disability community. So I'll hand over to you now, Mary. Thanks.
Thank you very much, Evelyn. And I'm going to share with you. You can see the slides, yes?
Yeah, we can see them, Mary. Thank you.
Thank you. So I'm going to share with you my probably extensive experience at this stage in working with people with an intellectual disability, both as the principal investigator of IDS Tilda, but also as the director of the Trinity Centre for Ageing and ID, where we have a wide variety of studies. This here is a map of the world, and all of the dots here really signify longitudinal studies that have been conducted all over the world, looking at the determinants of health and well-being in the general population. And when Ireland was launching Tilda, which is led by Professor Roseanne Kenny, you had somebody like myself asking, why is it that no country in the world had ever before included people with an intellectual disability in these longitudinal studies? And I was very concerned that we would have a similar study launched in Ireland and that people would not be included. People at the time told me it would be very difficult, they would be too complex, there would be huge consent and ethical issues. We work very closely with people, and I'm really delighted to say that we are the first country in the world to have included people with an intellectual disability in tandem with a generic ageing study. And really the objectives of it are to understand the health characteristics of people aging with an ID, to examine the service needs and service utilisation, and to identify the disparities in health status of people compared to that of the general population with data yielded by Tilda, and to support evidence-informed practices and evaluation. People weren't included in previous longitudinal studies, despite our understanding and knowledge that we have much higher mortality rates in people with ID compared to the general population, that there's huge health disparities and huge health inequities. So we launched this study similar to Tilda in 2007. So we are, as I said, the first nationally representative longitudinal study comparable to the general population. And over the 10 years of the study at wave 3, we had a 93% response rate. So people with intellectual disability enjoyed and were able to participate in a study of this nature. And this here just shows you the map of Ireland, and people for this study were randomly selected to the National Intellectual Disability Database at the time. But from the very beginning, and this was in 2006, 2007, long before there was any conversation of PPI, I didn't even perhaps realize that it was PPI that we were doing at the time. We had a very strong values framework which underpinned the study. Yes, there was a very strong conceptual framework, of course, which underpinned the study. But for us, at the very beginning, we had this strong conceptual framework. Nothing about us without us. So I know Peter's talked a lot about the good faith principle in conducting research. So from the very beginning, really, we were talking about respect for the individual, involving people with an intellectual disability from its inception, right through the design process, right now to the dissemination process, ensuring that we were adhering to the basic principles of good practice, things like justice, fairness, honesty, integrity. They were just so key and important for us, using a very person-centered approach, making sure that the approaches that we were using would empower people with intellectual disability to be able to partake, that they really would contribute to their lives, that people would have choice, and that would really promote people with an intellectual disability and their health and well-being. And it's just great now to see the study running for so many years, and really the translation of many of those findings to make real change and at a policy level, which are hugely impacting, hopefully, on the health and well-being of this population. And this just talks a little bit, and I know that Emily and Peter have already spoken about some of these issues, but this talks to the stages and complexity of ethical approval and really the process that's involved. So this is looking at wave 4, which was 2018 to 2011. We would have initially submitted our DPIA to Trinity, then an application for changes to our protocol to the Faculty of Health Sciences Research Ethics approval. When we got that ethical approval, we then had to apply to 52 research ethics committees across the country in order to also gain consent from them. So I can write the book on ethical approval across multiple committees. So I'm really glad to see something like the National Research Ethics Committee, and I hope this can be sustained beyond COVID. After we would have received that, we would have made an application to the HRCDC Consent Declaration Committee, and I really do want to thank Emily and the team. This has been a very positive experience for us. Really good help and really good feedback. So I found the whole experience of going to the HRCDC very positive indeed. Then we would have received approval of a consent declaration based on the conditions and recommendations. We then would inform the DPO and services of the approval, the conditions and the recommendations. And we're all well aware then we were in the middle of data collection when COVID hit in March 2020. We then had to update our DPIA back to the Faculty of Health Sciences Research Ethics Committee because we were now not visiting people and getting consent face to face. We applied then to the National Research COVID Research Committee because we had included in additional questions in relation to COVID. We had updated the consent declaration application and reapplied back to the HRCDC, informed Intellectual Disability Service Ethics Committees again, and now writing the annual report to the HRCDC. So that just gives you an overview of the the stages and the complexity, but the process that's involved in a study of this nature. So when we're working with people with an intellectual disability, one of our biggest concerns always is accessing the capability of people to give informed consent, and we have heard Peter talk about that. And we assume capability unless it is otherwise found that the person isn't capable. And if the person is considered not to have the capability, the interviewer will seek proxy agreement. And as Emily has said, this then requires a consent declaration from the HRCDC. But when we're looking at proxy respondents, it's really important that they be a knowledgeable informant, that they may know the person with ID for at least 6 months, be prepared to assist the participant in answering the questions, and the participant may require some assistance for some or all of the questions in the interview, depending on the topic being discussed. And the proxy may also assist to communicate maybe all of the answers if somebody has a severe level of intellectual disability and are not able to answer for themselves. So these are the 4 key questions that are almost foremost in our minds. So, and the first thing I want to say that informed consent, and I know Peter alluded to this, is a process. And really it's an ongoing process that ensures all the participants understand the potential risks and benefits of partaking in the study. And these are the 4 main elements. Disclosure. So did people with intellectual disability in our study, did they get all of the information they required about the study? But there's one thing in giving people information, and I know our colleague Louise Gallagher presented a very detailed overview of explicit consent last week. For me, it is really, did they understand the information? Was the information presented in a manner that they could understand it, using plain, unambiguous language? We would use the NALA guidelines and the European standards for easy read in all of our materials. And I'm going to show you some of our materials later on. And then capability. What was instigated to check their level of understanding? And I'm going to walk you through some of the things we do with respect to that. And then, of course, was consent given without coercion or pressure? And could they communicate their understanding either verbally or through sign language like LOV, which we would use in this field, or through technology? So before each interview, then field workers, they will go through an information booklet, and this information booklet will have been sent earlier on to the participant, at least 7 days before we are making contact again. Then participants will be provided with the opportunity to ask questions. We will confirm understanding on a consent form checklist. So we have a checklist which we will check off for the various groups of questions or the various sections of the protocol to make sure that people understand. Then we will ask participants to consign the consent form or to communicate it in some other way. And then if the participant doesn't have the capacity, as I said earlier, we will seek proxy assent. So we would involve people with an intellectual disability to help us. So PPI, and I know Emily spoke a lot about this, people with intellectual disability back as far as 2006, 2007 were very involved with us from the get-go. So they would have reviewed the questions, given opinions and provided their thoughts on the research questions using pictures, music, words and videos. And then people could choose to be included in some or not or all of the activities. And this is here working with some of our participants as they are assisting us to develop the accessible materials, our information booklets, our consent forms, etc. So we would have been working with people with intellectual disability themselves to help judge, well, are these understandable to the population that we are trying to support with this information? So they created the accessible voting cards, and that helped with the process. So we would have voting cards where people would say, put a star if they felt this was with respect to the readability of the particular forms, and the work then in the creation of information leaflets and consent forms. And I think Peter alluded to this, consent is just not one event, it's an ongoing process. So in wave 4 of IDS TILDA, we would, and across all the ways, we would firstly get consent to partake in the study. Written consent then is reaffirmed at each wave, and process consent throughout the interview. So we have consent on recruitment before the interview and during the interview. And when we are going out to visit our participants, this is an appointment card that each of our participants will be sent in advance. So they will know the person that's going to come and talk through the information booklet with them. So this is Marianne Fallon, one of our PhD students. Marianne will tick off the day that she's coming, the date and the time, and that will be sent. And it just folds over in 2. It's very simple. And then if they are not able to keep the appointment, there's the phone number of who they can contact. And we found that having a picture ensured that the participant would know who is coming to visit them. And this is particularly important because this is a vulnerable population. And this is just an example here of some of the easy read materials. You know, at the start of the interview, you can find out more about the study. You can ask questions, then how long the interview will take. You can stop and take a break, and you can bring a support person if you wish. And we introduced a comprehensive health fair in wave 4, and this is Dr. Eilish Burke, and Eilish is an Usher Assistant Professor in the School of Nursing and Midwifery, and Eilish really was responsible for running of the health fair. And we introduced a much more expansive suite of measures in wave 4. And though these additional measures were driven from findings of the previous waves. And we always knew that, you know, doing health assessments and more complex health assessments might be challenging for people with an intellectual disability. So we really had to make every effort to make this explain what was happening, make sure that they understood, and that the consent for each part. So this was the process. So a nurse would have met them, there was 3 bays, and a nurse would have met them, they would have introduced and explained what was happening, and they would have gained consent for the person to start engaging in the health fair. The participant will be given an armband then, which they quite very much enjoyed. And we knew then as they moved across the various bays that they had given consent, that the overall process had been explained and consent was given. So the first bay would have done the nutritional assessment, but when they moved to bay 2, again, there was a meet and greet. We reaffirmed consent. We provided explanations then of what was happening in this bay, and this was around the physical health assessment. And bay 3, again, same process, and this was around the cognitive health assessment. So people could participate in one aspect, multiple aspects, or no aspects. And then when participants completed the health fair, then we gave them a card then with the results, and everybody got a certificate of achievement for their participation, which they very much enjoyed. So this is an example here of one of the information booklets and with respect to the health assessment. And these booklets, I'm very happy to share our materials. You can download them from our site. So this just gives you an idea of what the booklet would look like. Introduction, a study about growing older for people with intellectual disability in Ireland. We need your help. We're going to hold a health fair as part of it. This will help us learn about how people will grow old, and we're going to ask your permission to do the health fair, and you do not have to take part, it's your choice. And then the booklets are broken up into various sections, but this is just the section I pulled out for today, looking at sensitive information. Very clear, simple explanations to people. So what we will do with your private information, all your information will be kept safe and private. No one will be able to see your information. Your name will not be in the report, only researchers, and then they're only allowed to use under the strict permission of myself. And then you decide. So this is very much, again, breaking it down into bite-sized pieces so that people with intellectual disability can understand the information. And at the end, you decide. Remember, you do not have to do any of the assessments if you're not able to, or you do not want to. It's your choice. And this is an example here. It will say within the health fair, there was various measures that we were doing. So a hand grip strength and time, get up and go. And this was the information leaflet with respect to the grip strength. So the nurse would have went through this, explained this using this information sheet, and then participants could decide whether or not they wanted to engage. And we had something similar for every single one of the 24 measures across the study. And then this is the consent form that people would fill in. And you can see here, I'm sorry if it's not that clear, but I've read, I've had the information booklet about the study read to me. The researcher has explained all about the study. Any questions that I had were answered, and et cetera, and people ticked off each of those various sections. And then this was the consent form that people had, and they would sign or they would mark their name. And then if we had somebody supporting them, because we were always concerned, does the person really understand? And this would be the person who is supporting them may also, if somebody isn't, we're not fully sure, will also assist us in judging that. And this is the results card that people would get. We felt it was receiving meaningful results with any measures outside normal parameters was highlighted, and they were just given this card and instructed then to show it to their doctor. So if there was any of the measures outside the normal parameters, we would put them on a card and give them to the individual and ask them to take them to the doctor. And, you know, for many years now, we know that people with Down syndrome are particularly at very high risk of developing dementia. And similar to the like of IDS tilde, it is really quite extraordinary that despite our awareness of the very high risk, they have seldom been included in prevention trials. We know that the risk of developing dementia for people with Down syndrome after the age of 65 years is almost 80%. So this is really concerning. And the big question has always been for me is, why haven't we done more around prevention? And this is Mei-Lin Yap. Mei-Lin Yap is now employed by the Trinity Centre. She works with us, has been working with us for quite a period. And she's our Ambassador Liaison Officer. And this is what Mei-Lin had to say. So it's really important that we include the voices of people with intellectual disability in the conversation. Like everybody here, I have dreams for the future. There are things I want to do, and I know that dementia might play a part in my life too. So when you start talking about dementia, I want to be included in that conversation. I want to be included in the conversation about my future. I want to be empowered so that I can choose how to reduce the risk of dementia. And that's from Mei-Lin. And this here is Professor Emer McGlinchey here. And Emer is also now employed in the Trinity School of Nursing and Midwifery. And Emer has been and works also to the Global Brain Health Institute, and she was a fellow. And Emer did one of the first studies looking at brain training in people with Down syndrome as part of a PhD with me. And really, we were interested in understanding if brain exercises for adults with Down syndrome could improve executive functioning. And this was called the BEAD study. But this is just an example of another information sheet that was developed for this program. So again, setting out what the program was about. The brain training is a set of puzzles and games. They're exercise for your brain. What is the project? The project wants to see if doing a brain training program will help keep your brain healthy. To do this, we will do some tests at the start of the study and also another 2 times. We want to see if brain training made a difference and why is it important. And then we had a quiz here, and the quiz was done in true or false questions. I have to take part in the study, yes or no. I will do some tests, yes or no. I will be given computer games and my name will be written in a report, yes or no. And I will keep the iPad after the study. Because that was a concern for us. We were using iPad technology and giving people an iPad for the duration of the study. And we were really concerned about taking that iPad away then after the study period, and if people really liked using this device and what that would mean. And we needed to make sure that people were aware so they weren't under any false impression that they were going to be able to keep this post the study. But we also work with the carers to see how they could purchase an iPad if they wish to after the study was over. And again, this is the consent form. Very simple, easy read. I have read and understand the information booklet. I know who to call if I have questions, etc., etc. So we would have used this and combined this with the quiz to doubly check that people really did understand. And we have also used innovative methods ensuring that people are fully informed. So on the one of the information booklets, we would have a QR code. People scan in this, and we will have one of our researchers perhaps talking through the study or using sign language in this case to explain the study. And this is Niamh, who I don't know who worked with Ailish, and she is explaining here a study a new study to participants, and I'll just show you a brief snippet of this.
Hello, my name is Niamh. I would like to go to your town to listen and understand more about you. I'm sending you a booklet. Please read this booklet. There is more information and you can get help if you need to. When you've read this booklet, please say yes or no. I look forward to going and seeing you soon. Bye-bye.
An example of, I think, the innovative approaches that we must now try to develop if we are really serious about making sure that people with an intellectual disability are fully informed. And we have a whole series of these initiatives. And it's really wonderful to see Niamh. Niamh was an undergraduate intellectual disability nursing student who had got a summer fellowship from the Health Research Board. So, I mean, that is really fantastic to see the next generation really taking this on in this manner. But we also would have paid great attention to the recruitment and the training of field workers. So unlike the Tilda study, which perhaps hire a company like Epsis Mori to complete the interviews, that simply was not feasible or possible for IDS Tilda. We needed to ensure that people who were going to meet our participants had a background in intellectual disability, had perhaps worked at some time with people with intellectual disability, and they all would have undertaken intensive training. We would have run a 3 to 5 day training for all their field workers, and as part of that training it would include issues like data protection, confidentiality, but particularly around how to deal with consent issues and how to follow up and contact people out in the field if they had any concerns. So we can share with you as well what that training program looks like also. And again, we would have people like Paddy and Melin are members of our steering committee. And again, we are using, this is some of our participants now with intellectual disability who are evaluating the field worker training and the ability of people, of our field workers to carry out the interviews. So they are the people who's evaluating their ability to get consent and explain the study. So thank you very much to everyone.
Thank you, Mary. Sorry to speak over you there. I was just conscious of the time. Really appreciate that presentation. I mean, I think IDS Tilda are really leading the way. I know I've said it to you before in the information leaflets and consent forms. And I suppose from my own perspective, I strongly feel that we need to be sort of focusing more on the process rather than the forms themselves. And I think you really showed us in your presentation how important the process of consenting is, you know, as aside from just the material that we present. So I think we could certainly all learn from you. But I'm going to welcome back the other members of the panel now for the Q&A. We've had quite a few questions in around the consent process and the consent forms themselves. So I'm going to just start with the first question here. I'd like to pose it to David. So the question is, how can we include everything which is advised by the ICH Good Clinical Practice, GDPR and health research regs, and yet make consents easy to read and understandable?
Thanks, Evelyn. I think the first thing I'd say, you know, I think Mary's presentation just now was a really incredible walkthrough of how these kind of things can be achieved. You know, in particularly talking about people in the cohorts of intellectual disability. So it shows kind of an example of kind of the layered approach, the time taken, exploring the alternative methods that are available to make sure that information is presented in a clear and accessible way. And it shows the sort of the benefit which is recommended in the guidance of the European Data Protection Board on transparency, of understanding your audience, so that, you know, when you're approaching your transparency requirements through participant information leaflets or whatever other means, you come from it from the perspective of understanding who the audience is and how they will understand it. So, I mean, that is the first piece of data protection guidance that I would refer to, that I just mentioned, the guidance of the EDPB on transparency in GDPR. The EDPB is also planning to bring out further guidelines on the specific application of GDPR to scientific research that I think will be of benefit in applying the principle of transparency in this context. And subsequent to that, the DPC in Ireland, we do intend to bring forward guidance and information on the application of the principle of transparency. I think, you know, this came up last week as well, that there was a lot of information to be got across. But I think the examples that have been highlighted this afternoon, and I think you mentioned it yourself, you know, sort of about going kind of on sort of a consent, you know, journey with the participants, rather than you know, looking to get everything into one form, is maybe the way through it, and it's really about understanding the cohort.
Yeah, I think it's that researchers and DPOs are maybe a bit nervous to be like the first institute to change direction. And I know we've spoken about this before, but perhaps one of the issues is the fact that we try to combine kind of the informed consent piece and the explicit consent piece into one document. And it's just become unwieldy, you know. So I think there are solutions there, but I think individual researchers and DPOs are kind of nervous to make that first move. So I suppose, you know, researchers are wondering what your remit is in the DPC, and as to whether you can offer specific guidance on, you know, information leaflets and consent forms.
I will mention as well, and because I know it came up as a question last week and we didn't get time to address it, but the Health Research Data Protection Network, put together by CRDI, does have a couple of documents with us for review at the moment in this space, and we are getting around to that. Our ability to engage with people in looking at documents and reviewing them has been really severely curtailed this year, you know, due to our involvement on various COVID-related projects with government. But I think that's a really good way forward, is for the sector, you know, through the various networks, to bring forward template documents, examples, and we do want to participate in that. Template documents and this kind of guidance needs to come from the sector, because we don't, you know, when we're sitting in our offices in the DPC, we don't have an on the ground understanding of what goes on. We do try to get out. Again, all of this outreach activity was curtailed massively in the last 18 months by COVID. But we have, you know, tried to get out and attend at clinical research facilities to talk to researchers, to try to understand what their difficulties are in applying GDPR to their actions. So I think the work needs to come from that side, but we're more than happy to work with sectors. And indeed, one of the things that I think would be worth looking at down the road, and this will come from a European level as well, is the idea of a code of conduct under GDPR. Article 40 of the GDPR, as many of you will know, provides for the development of codes of conduct for data processing in certain sectors, and I think health research could be one where that would provide some guidance, clarity and certainty for researchers, but also as an accountability and transparency mechanism for individuals looking to understand what's happening when they sign up to a project.
Great, and I do appreciate that willingness, and I appreciate the constraints on your time as well. Moving on to the next question, I might put this one to Peter, who I hope is still with us. We can't see you, Peter.
I'm still with you, yes.
You're still with us, great.
Yep.
What policy protections can be put in place for consenting patients who are in a vulnerable situation? An example given here was on their way to surgery, but indeed somebody else has put in a question about you know, patients during COVID as well, where there's obviously restraints on the amount of time you can actually spend with the patient, consenting them. Would you be able to comment on that?
Yeah, I was surprised when I saw the example about a patient on the way to surgery. I think that when we go back to the main principles of valid consent, it has to be informed and it has to be voluntary and freely given. If you take those two together, and I think as Mary said, it's not just enough to give people information. You must give them time to digest that information, and it must be given to them in a way that they can understand readily, and given people's varying capacity. And we have now, say, a large immigrant population in this country. You would want to make sure that language and everything was explained to people as fully as possible. So what I think is this, that informed consent and voluntary consent depend on the timeliness principle. Asking somebody as he or she, and I just imagine myself on the trolley being wheeled down the corridor and somebody saying, we have a brilliant research study, and if we could just get your informed consent. To be frank, I can't see that being acceptable under any circumstances. And even in the context of COVID, I wouldn't like to think that COVID was used as a reason as to why there would be compromises on the concept of informed consent. Mention was made of the Solidarity, World Health Organization Solidarity trial. Well, actually, it can be difficult maybe to get somebody who's in a ventilator room or isolated to actually sign the document. But that doesn't mean that you can't give them time to consider the patient information leaflets. So I would be skeptical of any situation where a person was rushed for whatever reason to give consent. There may be exceptional circumstances where that may be necessary. Perhaps somebody is in an emergency care situation unconscious and they need to make a decision. But the very prospect of somebody chasing after somebody who's on a trolley going to surgery to get consent is, I think, wholly at variance with the fact that it should be informed and it should be voluntary. And I don't think that we really need to provide policy guidance on that. I think that intuitively anybody carrying out research would recognize that it's not just not best practice, it's simply not acceptable practice.
I appreciate that response, Peter. I think that's very clear. So moving on to the next question, I might actually ask Mary this one. This is about, should patients be consented to take part in research by an informed, expert, independent person whose first priority is to consent the individual? So somebody completely independent to the research. And I suppose this would avoid any imbalance of power. I understand there are some independent advocacy services such as SAGE that might have some kind of parallel.
Yeah, well, I mean, it certainly is an interesting question. You know, I think we have to, you know, I think for the research studies that we're involved in, we're not working in those health areas with that population. So in some ways there is a kind of an independence because we're not the person who's with them, you know, supporting them all the time. So in that way, it probably does create some degree of independence. I think involving people with intellectual disability, as we probably even will develop on going forward, to assist in that process may be a useful way to consider. And we would use groups like the various advocacy forums, which are within intellectual disability, to assist us through some of that process as well. So I think, yes, this is an interesting area going forward as well. Yeah.
Yeah, I mean, I don't know if it's something that's maybe on the agenda, but I suppose it's, you know, in the Department of Health or the DPC, but it's a very interesting question, I think, that one. We have another question.
If I could just comment briefly on that, Evelyn, on the idea of, you know, a requirement for an external independent person. I think the view of the EDPB, you know, which will be expressed and has already been expressed in certain areas, is that it's not a requirement, you know, under data protection law, and there's certainly no impediment in data protection law to somebody who's involved in care and treatment also being involved in obtaining consent. What the GDPR requires is that the data controller considers the risk and considers whether an imbalance of power exists. And puts factors in place to mitigate that risk. So it's not a black or white issue, you know, that the consultants can or can't be involved in the consent process, but the controller must build that into their risk assessment.
Okay, thank you for that, David. We have a couple of questions here actually on the informed consent obtained prior to the HRR. I'm just conscious of the time, so we might move on to those. One here, maybe Emily, you might be able to comment on this. Are the HRCDC and legislators aware that most consents won't reach the threshold of informed consent?
Yeah, thanks, Evelyn. Yeah, so I suppose from the HRCDC's perspective, we have received a series of applications in the very early days for research studies that would have commenced prior to the regulations, and those studies would have at that time considered that they had consent in accordance with the previous directive. Now, when the amendments came in, we did an exercise and we contacted all our applicants where those applications were pending to determine if they still required a consent declaration. And what we're actually seeing is a lot of those data controllers are coming back saying, actually, yes, we still require a consent declaration because we've reviewed our consent protocols as they would have been implemented back then, and they consider them not in compliance with the previous directive. So we're seeing a series of that coming to us, and I know we're still in that process of trying to contact applicants to determine that. So so they're determining that there's gaps in those consent protocols previously.
Yeah, certainly from our own perspective, as you're aware, it seems to have been common practice that information leaflets were printed on, say, hospital-headed paper, and unfortunately the associated affiliate institution wasn't named. So when we're reviewing, we cannot stand over that and say that that's informed consent. So that's been our own experience of that.
Sorry, Evelyn, could I say something about that?
Yeah.
When the health research regulations came in, one of the first things that was represented to the department by groups such as Clinical Research Development Ireland was that absolutely informed consent under the EU Data Protection Directive had been obtained, and that therefore it was extremely unreasonable to ask people to go for reconsent since it had absolutely been obtained. In a good faith gesture and in consultation with the DPC, we therefore introduced the amendment that we did introduce. I have to say that from a legislative perspective, it would be extremely disappointing if it now transpired that, having understood that that was the situation, that it wasn't the situation. And I would point out that informed consent under the EU Data Protection Directive was a legal requirement for research that was carried out during the currency of the EU Data Protection Directive. So if one wanted to be pedantic, and on a Wednesday afternoon, nobody wants to be pedantic on these issues, it could be said that failure to have obtained informed consent during the currency of the EU Data Protection Directive in line with the directive meant that the researcher was in breach of data protection law. But then the only people who can comment on what a breach of data protection law actually is not the Department of Health, thankfully, but the DPC. So I'll leave it at that.
I mean, what I would say on that point is that the professor would have been named. It was more that the processes in place were to name the individuals rather than the institution. So there was transparency there, but I think it was just that the practice at the time was different to what we now understand to be, you know, being fully transparent. We have a couple of questions in here actually about consenting in children. So I might put this one to Peter first. Can you recommend any guidance that clearly lays out informed assent and consent processes for paediatric research, including when the child reaches the age of maturity?
Well, prior to this morning, myself, Emily and David met and we discussed it. So I'm going to defer in a moment to Emily and David. What I would say is that as a general principle in law, if a parent gives consent for an individual, when that individual is a child, then when the child reaches the age of majority, that consent has to be refreshed in the context of the individual concerned. But in terms of actual material, and I had a look and I couldn't find anything, but maybe Emily and David might have a supplementary and complementary view.
The only thing that might be useful to point out is that there is guidance on the TUSLA website and their research page, and they give guidance on consenting minors and children for research. And it's also set out in the National Consent Policy. And I know mirroring that, which isn't the same, but the Irish Medical Council also have guidelines in their ethical guidelines. So that might be useful to highlight. I think David may have further comments.
Yeah, just to mention that what the DPC has developed, so this isn't specific to health research or to consent, but it's a document called Children Front and Centre, the Fundamentals for a Child-Oriented Approach to Data Processing. And that sets out the views of the DPC in how the principles of data protection should be applied specifically in the processing of children's data. It relates in large part to the processing of children's data in the online context, but the principles that are laid out there apply across the board. And what I would just say briefly on that is that the theme that's expressed in that entire document is that the best interests of the child really should be considered above everything else. And that the application of data protection law should not be seen as a barrier to affecting the best interests of children.
Thank you all for that. I'm sure that will be very helpful to the audience. I'm just conscious of the time because we are at 2 o'clock. So just given the our collaborators here today, I suppose just one final question. The requirement for explicit consent can effectively exclude a large number of patients from research studies. This has come in for one participant. So for example, those suffering from delirium cannot consent. Are they being discriminated against? And I wonder, Mary, would you have any comment on that particular query there?
I think, you know, what I've done is to try to outline the process that we go through and breaking this up into bite-sized pieces and making sure that it is a process. But during an acute stage of delirium, again, a bit like the surgery, it may be very difficult for somebody to even understand what's happening. So you have to look at the appropriateness during that particular acute period of time. That would be my opinion on that. But certainly, I hope the documents I gave will be of assistance. Emily might want to.
Yeah, I suppose just from our perspective that, you know, the regulations never intended to exclude anyone from research. And in fact, informed consent was always, you know, was always required. And the HRCDC is there to facilitate those exact scenarios when it's not feasible to get informed consent from particular individuals. So, you know, similarly, we would see consent declarations being sought for areas for other vulnerable groups, such as, you know, the IDS tilde cohort. So I don't see any reason why the research cannot be carried out, you know, for those particular individuals. And maybe they're if we're talking about delirium, maybe that's a temporary state as well. So deferred consent may be sought. So again, there are various mechanisms there, and particularly the HRCDC is there to facilitate that.
Thank you, Emily and Mary. And there's one final question here, actually, which I do think is an important one. So I'm going to put this one to David. And if we don't have time, you know, to conclude, you know, we can follow up. But it's about the participants' rights and the fact that these can be limited in certain situations. And, you know, we put this statement in our information leaflets that, you know, if it would seriously impair the research, then, you know, the data subject rights may not or may be limited. Is there any guidance, or is the DPC looking at how we can communicate better to data subjects the limitations on their rights?
Yeah, absolutely. So I think this question, you know, largely arises with the limitation to the right to erasure of data following the withdrawal of consent, and the GDPR does envisage that the processing of data may continue following the withdrawal of consent where it's deemed necessary, you know, in order to protect the validity of the research project. You know, absolutely, we can look at guidance in this area. I think what I would look first of all to is the guidelines of the EDPB expected later this year. The EDPB is consulting a stakeholder engagement this week, which will inform the outcome of those guidelines. subsequent to that, I think the DPC will be in a position to develop our own guidance. But also, as I mentioned, we're happy to talk to other groups. We've met, for example, with the Irish Cancer Society and held a webinar there for patients or family members of people suffering from cancer to try to help them to understand the data protection rights. And that's a key part of it, is understanding how you can be facilitated in exercising your rights, but also what the limitations may be on those. Just on the withdrawal of consent issue, I think what's important for researchers is to understand themselves beforehand, what they can and can't do, and to understand how the withdrawal of consent works, and then following on from that, figure out how to best communicate that to participants, because it's clearly very important that people don't end up in a situation of being surprised to find out that their information may remain as part of a study, and that it's not a situation where a decision is being made late in the day that then has to be communicated to people. So to understand at the outset of the study what will happen if people withdraw, and then determine how best to communicate that.
That's great, thank you, David. So I think on that note, I would like to thank each of our panel members for joining us today. So thank you very much to Peter, Emily, David and Professor Mary McCarran for taking the time to be with us at Trinity's Masterclass on Exploring Consent. I'd also like to give my sincere thanks to Michael Foley and Gavin Dan from IDS Tilda, without whom this event would not have been possible. And I would like to give thanks on behalf of the research community, and to also thank the research community for joining us today. So we will be in touch as soon as we can with the videos and the Q&A follow-up, and we will make sure that we answer all of your questions, because I suppose each of us do take this very seriously. Thank you for your time, everyone, and we'll be in touch soon.